on the record, and will be handled in English. Mr. Hamran, if I may ask you to start, please.
Thank you so much for the floor. Ladies and gentlemen, let me welcome you on behalf of my colleagues and myself here to Eurojust. Whether you are joining online or you are physically present here, you are most welcome, and thank you so much for your interest. As you know, tomorrow it will be exactly 1 year ago that Ukraine woke up to the sound of sirens and shelling, and nothing can make up for the terrible loss and destruction suffered by the Ukrainian people ever since. But from day one it became very clear that the international legal or judicial community would do whatever it takes to help bring those responsible to justice. And I'm incredibly proud that Eurojust and the European Union is in the center of all these accountability efforts. During today's briefing, my colleagues and I will update you on different lines of actions which have been taken in the past 12 months, and also shed a bit more light on expected developments in the near future. So let me start with the core international crime evidence database, which is hosted now here at Eurojust, and as you may recall, Eurojust got a reinforced legal mandate in last June. And the idea of behind this database is to address many challenges resulting from a scattered operational landscape with evidence located in several jurisdictions and collected by a wide range of stakeholders. There are important benefits to centrally preserving, storing and analyzing core crime evidence. First of all, let me tell you that it allows to shed light not only on individual offenses, however also on the systemic actions behind them. And this is very important for the legal qualification, because then we can address different crimes and of course different perpetrators. It makes also easier to determine a prosecutorial strategy with the greatest chance of success. Again, as you may know, one deed may constitute several crimes, and we as prosecutors have to actually check what's the best strategy, whether we have whether we have documented different elements of core international crimes, and if yes, then how strong of a case will be or might be before the court. Another benefit is the early identification of parallel investigations. As you know, today we have 21 national investigations, and early identification of overlaps may lead to efficient use of resources and reduced risk of legal errors. Crucially, maintaining an overview of interviewed victims helps to avoid re-victimization by repeated interviews. And with this database, there are no fishing expeditions for evidence. Instead, we will have targeted evidence searches, and of course this will lead to faster and more effective national investigations. And finally, the possibility of secure storage outside of the location of an armed conflict can prevent the loss of evidence. In addition to all these benefits, there are other few aspects which I would like to share with you today. Certain principles which are strongly embedded in this database. First, it's only intended for digital evidence from judicial files, so from legal proceedings, which means that non-governmental organizations and civil societies will not be able to send their data directly to Eurojust. Instead, they should proceed by contacting national judicial authorities. Second principle relates to the ownership of data. The ownership of evidence included in the database will always remain with the country or a partner that originally provided it. Under no condition will Eurojust be able to share evidence without the consent of the owner. And thirdly and finally, it's important to mention that Eurojust will not actively collecting evidence itself. Let me also tell you that this database stands on 3 pillars. First of all, we have now safe transmission module for safe transmission of digital evidence. Then second pillar or component will be secure storage. And the last, third one, relates to advanced analysis. I'm pleased to share with you that now Eurojust successfully implemented first 2 components. So we have now a technology implemented for safe transmission of evidence from our partners to Eurojust. We have also secured state-of-the-art storage for digital evidence. And we are implementing this advanced analytical tool, and we expect the database will be fully operational by summer this year. So while I'm convinced, ladies and gentlemen, that this database is a real game changer in the prosecution of core international crimes, it's just one of many ways in which Eurojust supports prosecutors working on Ukraine-related cases. As you know, Eurojust is supporting our partners in other areas, and let me now pass the floor to our Vice President, National Member for Lithuania, Margarita Šniūtytė-Daugelienė, who will tell you more about the joint investigation team which Eurojust has been supporting, and the upcoming International Center for the Prosecution of the Crime of Aggression. Margarita.
Thank you, Mr. President. On the 25th of March 2022, Eurojust helped, as you know already, to set up a joint investigation team, or JIT, focused on core international crimes committed in Ukraine. This joint investigation team originally included Lithuania, Poland, and Ukraine. Already after 1 month, in April, the ICC joined a JIT as a participant, and in May, Estonia, Latvia, and Slovakia became members, followed by Romania in October. The purpose of this joint investigation team is to facilitate the exchange of information and evidence between the partners and strengthen the coordination between those involved. Since its establishment, the JIT can count on Eurojust legal, analytical, financial, and logistical support. So far, Eurojust has assisted with the organization of 14 coordination meetings here at Eurojust, where JIT partners were able to discuss the most effective strategies and the way forward on investigation and prosecution of these international crimes. Eurojust has also provided nearly 200,000 euros in financial support, as well with encrypted phones, encrypted laptops, and other equipment. In addition, Eurojust ensures that work of the joint investigation team remains aligned with the national investigations related to the war in Ukraine. As it was mentioned by the President, this is essential because there are over 20 countries with Ukraine-related investigations, including 14 European Union member states, 4 other European countries, the United States and Canada. In the coming month, we will add a new dimension to our existing accountability efforts. On the 2nd of February this year, Commission President van der Leyen announced the initiative to establish an International Center for the Prosecution of Crime of Aggression, or ICPA, here at Eurojust. The ICPA will be part of the current joint investigation team support structure and focus on the collection, focus on analysis and preservation of evidence of the crime of aggression committed against Ukraine. Of course, it can be seen as an intermediary step and does not preempt the outcome of political discussions about the establishment of a special tribunal. Instead, the ICPA simply ensures that evidence of a crime of aggression is secured, and we do not lose precious time in building a case for the future prosecutions for the crime of aggression, wherever that prosecution will take place. By linking the ICPA to the current Joint Investigation Team's support, we can also ensure an optimal alignment with the national investigations into co-international crimes and investigation into crime of aggression. As for the implementation, the plans for the ICPA were very recently announced, so it's too early to provide you and to share more details about this or to provide you a concrete timeline. I could say just that we expect the prosecutors involved to work from the Hague on semi-permanent basis, and we hope and we aim to have the first building blocks in place already by this summer. And now I would like to pass the floor to my colleague Miroslava Krasnoborova, who is licensed prosecutor at Eurojust.
Thank you very much, Margarita. Indeed, as it has been 1 year since the start of full-fledged Russian invasion in Ukraine, and atrocities and destructions caused by Russia are colossal and endless. Millions of people have been forced to leave everything behind. Massive missile attacks are destroying the civilian infrastructure, and many have tragically lost their life. And this damage cannot be undone, but what we can do is to ensure that those responsible are brought to justice. From the very beginning, I feel a very strong support from my fellow prosecutors here at Eurojust and in their countries. And the decision to set up a JIT was taken only 6 days after the start of the aggressive war. And within a few weeks, we had the JIT agreement concluded. And this JIT gives Ukraine the possibility to closely cooperate with their counterparts in other countries and coordinate its investigation with those of other JIT members and also the ICC. It helps us to avoid duplication, agree on joint prosecutorial strategy, and indicate where we could use the support of our partners. At the same time, it is Ukraine's firm belief that the accountability efforts should also include the prosecution of the leadership of the Russian Federation for the crime of aggression. The impunity for this supreme international crime should never be accepted. And Ukraine, therefore, strongly welcomes the decision to set up the ICPA at Eurojust and hopes that this will accelerate the ongoing discussions about the eventual prosecution of the crime of aggression. And today today's press briefing was mainly about the different forms of coordination taking place at Eurojust, but there are also some recent strategic initiatives worth highlighting. And one of them is that at the Ukraine's Accountability Conference held in The Hague on 14th of July last year, 45 countries agreed on the establishment of a dialogue group. And we are looking forward for the kickoff of this dialogue group, and Eurojust and Ukraine Prosecutors General's Office will co-chair a work stream on national investigations. The aim of this workstream will be to promote understanding of key challenges faced in national investigative work and jointly identify a solution also at a policy level. And also about the other strategic developments, I will give the floor to my colleague, Mateusz Petric. He is the head of Genocide Network Secretariat that is hosted here at Eurojust. Thank you.
Many thanks, Miroslava. Good morning to all. So a few words on the Genocide Network. That's a unique center of expertise that connects national investigators and prosecutors who are specialized in dealing with core international crimes cases on a national level. It connects also UN mechanisms for Syria, for Iraq, for Myanmar, the Office of the Prosecutor of the ICC, and several civil society organizations. It goes without saying that the war in Ukraine has prompted a great number of new initiatives in support of accountability. In the past months, we have, in cooperation with the European Judicial Training Network, organized a series of executive workshops for prosecutors, judges, and law enforcement officers dealing with core international crime cases, focusing on the JIT countries that were mentioned earlier, and that, of course, includes Ukraine. The investigation and prosecution of core international crime cases require specialized expertise to manage the scale and challenges of these investigations. So through these workshops and other knowledge-sharing activities, we aim to increase the capacity of involved countries as quickly and efficiently as possible. That's also happening where we have transfer of knowledge between the prosecutors with long universal jurisdiction cases who offer their expertise. We have also drafted several publications in support of those in the field, with a particular focus on cooperation with civil society organizations. They play an increasingly important role in accountability efforts, but they need to respect key principles to preserve the integrity of information and evidence in order to avoid consequent legal questions, such as chain of custody or multiple interviews of the same witness. With this in mind, we joined forces with the Office of the Prosecutor of the ICC to publish guidelines for civil society organizations on documenting international crimes and human rights violations for accountability purposes. They were launched in September last year, and we are expecting to publish also French, Arabic, Spanish, and Ukrainian language version in the coming months, because the original version was English. We also work closely with various civil society organizations that document crimes committed in Ukraine and provided national authorities with an overview of their activities as well as entry contact points, and we pursue this work on an ongoing basis. Finally, and again together with the Office of the Prosecutor of the ICC, we have issued guidance to national authorities in order to assist frontline officers and others who are in contact with refugees from Ukraine to screen and identify victims and witnesses. It's a work that, of course, is benefited by all working on these cases. In the coming period, the Genocide Network, together with all our partners, will continue to develop knowledge-building activities in support of those involved in the accountability efforts. An event for this purpose, the 8th EU Day Against Impunity, which will take place on 23rd of May this year, will be dedicated to the exchange of best practices and experiences in the development of new war crimes unit at national level. Through these and other initiatives, we hope to contribute to the joint ambition to bring justice to the people of Ukraine.
Thank you, Mateusz. Thank you to all speakers. We now have time for questions from your side. You can use the chat function for this for those of you joining online. And if you could please indicate which media organization you represent and to who your question is addressed. But I already see a question here, the gentleman there in the back, and we'll try to have online and questions from here at the same time. Thank you.
Very much appreciate. My name is Daniel Koop. I work.
Sorry.
Thank you very much. My name is Daniel Koop. I work for the German television channel Welt. I have a very theoretical question. Do you think there will be a day in the future, and how do you imagine this day, and how do you imagine, which court there might be in charge, that we see Vladimir Putin, facing, charges for what is happening in Ukraine right now? Thank you.
Mr. Hamron, might you want to take that?
Our experience so far shows that documenting, investigating and prosecuting core international crimes requires international efforts. This is what we have been doing as Eurojust, building partnership between countries, between different international organizations and agencies to make sure that there is one day, definitely, which those perpetrators will be brought to justice.
Okay, thank you. First a question we have online and then I'll go back to the room. A question from Libération, French newspaper. How many inquiries have been opened by the Ukrainian authorities so far? Perhaps Miroslava, can you give an update?
Thank you very much, Tom. Thank you for the question. You know, I was especially preparing for this briefing and I checked with my colleagues about the latest number. And as of this morning, it was more than 71,000 alleged war crimes and also more than 16,000 of alleged crimes against national security of Ukraine. This is as of this morning.
Thank you for that latest figure. Sorry, I saw a question from you there, then I'll go to you, and then, yes, please.
Hi, Matt, whoops. This is not, there we go. Matt Steinglass from The Economist. I had a question for Mr. Pezdrich about the guidelines for civil society organizations and for gathering evidence. Are those guidelines written specifically with a view towards genocide? Are they generally applicable to all sorts of crimes that might be addressed in war crimes and so forth? And are there difficulties that arise in terms of how you encourage organizations to do their interviewing to gather evidence for specific crimes?
Yeah, thank you very much. The guidelines are written, of course, for the core international crimes because that's sort of our field of work. But we have received very positive feedback from many NGOs operating on the ground. They plan to use some of those features also for other crime areas like trafficking or torture, so when they're engaging with victims of trafficking human beings or torture and so on and so forth. So in a way, there are a set of principles that allow civil society organizations to apply them accordingly to their needs. So I think they're quite flexible, but they do set certain standards on sort of do and don'ts. With a view of consequent later judicial process for accountability. So either and we don't specific either that can take place at the ICC or at national authority. So in that way they're quite flexible, but still giving sufficient guidelines on what you should do or what you should avoid, or how you should do it as well as an NGO. So, and that's why we also now embark on this process of translating as well these guidelines to really allow broad dissemination, because they're not, of course, the initiative was coming from NGOs that operated on the ground in Ukraine, and of course with the war in Ukraine, but they can be applicable to any other situation as well. And that's why, together with the Office of the Prosecutor of the ICC, we really want to ensure a broad outreach of these guidelines to as many NGOs as possible.
Is it possible to give an example of a do and a don't?
Can you use the microphone, sorry?
Is it possible to give an example of a do and a don't?
Yeah. Absolutely. The initial one is ask witness if he or she has already given testimony. And if that's yes, then avoid further questioning, because if the person already gave one testimony, that's I think sufficient. We really want to avoid re-interviewing when one witness gives sort of an account to 10, 20 different either civil society organizations, media, humanitarian works, and so on, because that actually impedes the use of that testimony later on in the court.
Thank you. We have a question from Le Monde.
Stéphanie Maupin from Le Monde. Yes. I would like to know how the ICPA is going to work. Will it be autonomous from Eurojust? Will it be utilize its own budget, its own organization? Who is going to lead it? And I understand that the JIT doesn't do any investigation, but the ICPA, I suppose, will do some investigation. So can you give more details on it?
Let me just correct you. Exactly, the JIT is doing the investigation. So those who are in the joint investigation team are prosecutors, police officers, and investigators. Those are collecting pieces of evidence and documenting different core international crimes. The ICPA will be a support structure to those in field, making sure that there is intensified cooperation between those countries, having investigation concerning the crime of aggression, or are in the possession of having a piece of evidence which is proving certain elements of the crime of aggression. So ICPA will make sure that there are no legal impediments, financial impediments, communication impediments between judicial authorities to exchange evidence, to talk, and Eurojust will be providing logistical support, analytical support, legal support to all those who are building the file concerning the case of aggression.
Will it be independent from the JIT, or will it work like, for example, the ICC is linked with the JIT? So will it be independent or not, and who is going to lead it?
Yes, it's going to be an autonomous independent structure providing dedicated support to those countries. Who is going to lead it is still too early to say because still everything is in the making. But as soon as we have more clarity, we will organize another press briefing and tell you a bit more.
Okay, just can you say something about the process to choose the future leaders of this? It will be an election. Will it be I don't know, just I don't know what, if you know about the process.
All these type of cases or questions are now subject of considerations. As soon as we are in the position to tell you a bit more, we will definitely do so.
Okay, we go to a question here in the room of AP, then another question online, and then your question. Yep.
Mike Corder from AP. Mr. Hamran, maybe this is just addressed, but can you tell me what kind of overlap there will be between these two organisations here at Eurojust? And also, can you give us some examples of the type of evidence you need to prove the crime of aggression?
First of all, I would like to clarify that the ICPA, it's not going to be a new organization. It's not going to be a legal entity created by treaty. So it will be an internal support structure hosted by Eurojust and providing dedicated support to a joint investigation team and to those countries which have investigation concerning the crime of aggression. Now, obviously, we will use for the crime of aggression the legal definition of the crime of aggression in the Rome Statute concerning the Kampala agreements, and we have to then step by step start collecting different elements which lead to decisions concerning the aggression. So who actually gave the instruction to invade the country and so on. So this would be the part of other efforts.
Ms. Schnoddy-Dogelien, would you like to come in on this?
I just can add what Mr. President said. It's very important to understand that the ICPA will be part of the current joint investigation team, and the prosecutors who will work in this ICPA will be the members of this joint investigation team. And Eurojust, as it was mentioned, will provide additional support to this ICPA. And now we are working on this.
Okay, I have a question. Sorry, I have a question online, then we have two more questions in the room. Question from EU Observer. in case there's no large UN General Assembly majority supporting a special tribunal, are you confident that prosecutors will have the necessary legal basis to bring the top political and military leadership, including Mr. Putin, to court?
I would say that the main idea of ICPA is to build the case of investigating the crime of aggression, and the key issue for ICPA to have the proper legal base that is in place. So it's fully the all legal base for the ICPA is here, and the prosecutors and investigators who will work on this case, they have all proper legal instruments already in place, and all the evidences that will be received within the ICPA, they would be admissible in any court. Would it be Ukrainian national court, would it be a national court of any other country, or any international court?
Okay, thank you. We have a question from the gentleman in the middle, then we go to Reuters. Sorry, first the gentleman.
Good morning, Edith de Vries from the Independent European Daily. I have a question for the chair and probably for the prosecution. You said that in the database only information will be put through national governments, not from NGOs. What does this mean for the material that already has been gathered by Bellingcat? Does that mean that the Bellingcat material will not go to your office? That's one question. And the other question for the prosecutor probably is, are you already collecting evidence on the ground? Do you already have your own boots on the ground? How many inspectors are already gathering material that comes straight to your prosecution office?
The first part, Mr. Hamron, please.
Thank you so much. Concerning the information already collected by Bellingcat, definitely this is very useful for prosecutors, but Bellingcat needs to speak with national authorities, prosecution authorities, and offer their collected material to them, because we as Eurojust, we do not have a legal mandate to work with NGOs and civil societies directly, as we are supporting only national investigations. However, if this transfer can be done through national authorities, we can then, of course, work with all the data from Bellingcat.
So, I just double check on question. So if the prosecutors are already working on the case of aggression? Yes, indeed. The case of aggression was immediately started in Ukraine and is investigated in Ukraine. And the definition of the crime of aggression is a bit wider in Ukrainian legislation, but the case is ongoing, and indeed I cannot say how many prosecutors are working on it, but definitely they have some results, and they have some already notification of suspicion.
May I follow up one question,
Yep.
please?
Yes, please.
Follow up on the prosecution matter. Are you also considering the possibility for prosecution according to Ukrainian law? Bear in mind the Lockerbie trials in the Netherlands, according to that law being held here in The Hague or near The Hague. Is the Lockerbie construction, a court from there over here, is that also a possibility?
I cannot respond, precisely on your question, because there are a lot of different negotiations and different options for prosecution are discussed. But what I would say that all options are on the table.
Okay, thank you. We have a question here from Reuters, and then we have two more questions online.
My question for Mrs. Krasnoborova. When I was in Ukraine, I noticed when I was out with war crimes prosecutors in the field, they were literally investigating one crime while another crime was taking place, overwhelmed by the sheer scale of it, and you just mentioned the number of more than 71,000. What would be the most useful thing for Ukraine now to receive from the international community in terms of support? If you were to appeal to the international community and say, well, we need more experts on the ground, we need more financial support, what would this be? Thank you.
Thank you for your question. Yes, indeed, this is something like, as you know, like a snowball. So with every day it's more and more, and it's very difficult and challenges. There are difficulties and challenges in investigation, especially when some new territories of Ukraine are liberated and the huge amounts of the crimes are coming. And indeed, what we see is that the majority of these crimes has to be investigated and prosecuted in Ukraine. And indeed, we are very grateful to our foreign colleagues for all the support we receive. And maybe not of all the support is public, but indeed it's very valuable, and it's starting from the assistance on the ground, and also it's sharing some best practices, for example, for 3D scanning, etc. So this is something that is very important, because it's not only the one-time assistance, but it's also something that Ukrainian prosecutors and investigators can use in the future.
Okay, thank you. We have a few questions coming in from EFE, the Spanish press agency, perhaps for different speakers. Perhaps the first one for Ms. Krasnoborova. How many cases of alleged war crimes have already been investigated in the last year in Ukraine? Then second question, what is the amount of evidence you got already? Can you give an idea? Perhaps Mr. Hamman, Ms. Schnutti-de-Doglien. And the last question perhaps for her as well, how's the cooperation with the office of the ICC prosecutor, Mr. Khan, right now?
Okay, then I will look. I've looked for the numbers. It's good to have them in front of me. And as I mentioned, so it was registered more than 71,000 of the cases. So this is registered, and 276 persons were notified as suspicion. So for different type of crimes, this is. So they were some charges were brought towards these persons, and maybe to say that 99 persons the cases were sent to the court, and also as for numbers we have 26 verdicts. So
okay, thank you. Then the question on the amount of evidence. Can we say anything about that? How much evidence has already come in? Well, the question is, what is the amount of evidence you got already?
At this stage, we don't want to share this operation information.
Thank you. And then the last question, perhaps for Ms. Schnutti-de-Doglien. How's the cooperation with the office of ICC prosecutor, Mr. Khan, right now?
Our cooperation from the very beginning was very good and still remains very good. ICC is the participant to the joint investigation team, and we usually meet at the coordination meetings and discuss our investigation strategies. ICC have their own independent investigation, JIT partners as well have their own investigation, and our cooperation is very good.
Thank you very much. We have a few more questions online, one more here in the room, and we have about 45 minutes, so I'll go to two more questions which have come in online from Libération. The first one is perhaps a bit close to another question which was raised, but you mentioned the discussion about the crime of aggression. Are there any precise details about the creation of a tribunal ad hoc? Would this only be about crime of aggression, or could it be a larger mission? That's the first question which has come in from Libération. And then the second question from Libération, how would the joint investigation team and the ICPA could coordinate with the ICC?
Maybe I will take the first question. So indeed, so there are different discussions on the political level, and as far as we are here prosecutors, so I would say that for us as a prosecutors, we will need to have the proper legal framework to prosecute this crime, and also just maybe to be precise with regard to the type of crime. You know that the architecture of the accountability for for individual criminal responsibility is that we have several layers. So we have the Ukrainian national investigations that the majority of the crimes will be prosecuted there. Then we have other countries with universal jurisdictions who can also investigate the crimes which are under their jurisdiction, for example, crimes against humanity, other types of crime. And then we have this international level. And here, the ICC has its jurisdiction based on the referrals from the state parties towards the crime of war crimes, crimes of against humanity, and crime of genocide. And that's why, and there is only one, I would say, gap where we see it's a crime of aggression, and the main idea is to fulfill this gap, to avoid impunity and to ensure justice for everybody.
Thank you. Then a question here in the room from...
Hi, Malika, Courthouse News Service. Malika, Courthouse News Service. My understanding is that the Eurojust mandate does not include the crime of aggression, and so if the ICPA is housed under the JIT, which is part of Eurojust, what is the legal basis then for investigating the crime of aggression? And I have a similar question then for the evidence collection database. Is that going to be collecting evidence related to the crime of aggression?
Thank you so much for this question, because indeed this is a very important aspect. Indeed, I can confirm that the crime of aggression is not included in the Annex 1 in our regulation. However, in our regulation we have Article 3, Paragraph 3, which allows Eurojust to provide assistance at the request of a member state, also in other forms of crimes which are not listed in the annex. So the list is not is subject of changes, and this consideration already took place. There was a request from member states, and Eurojust granted support also to that crime of aggression.
Okay, thank you. Then, looking at the clock as well, I think we get to the last series of questions which have come in online from the Spanish daily El Periódico. Three questions. You've mentioned there are over 20 national investigations on alleged crimes regarding Ukraine, 14 of them from EU member states. Could you specify which are these member states? That's the first question. And could you give an idea on the timing and how long could it take an investigation to be ready to present a case to the court or a court? Perhaps first on, can we say which member states are exactly investigating? We have, of course, the countries in the JIT, but...
Yes. Yes, I can see that as these investigations are ongoing, so we cannot disclose which countries prosecute, investigate which crimes. It's the answer that should be given by national authorities. Maybe to another question.
You know, I wouldn't speculate on the timing, because and my response would be as soon as sufficient evidences would be collected, the case will go to the court. Because the key criteria, justice delayed, justice denied. As soon as we have a case, the case will go to the court.
Just may we can add that Ukrainian Prosecutor General Office already referred several cases, tens of cases to the court in relation to war crimes.
Okay, thank you very much for your answers and for your questions, ladies and gentlemen, and for your attendance. With these answers, we conclude this briefing. We've just issued for you a press release and background information on the Core International Crimes Evidence Database. This is all available online as well. And yeah, we will continue to update you regularly via this way, via these briefings. Thank you very much for your attendance, and see you next time. Thank you very much. And thanks to all the speakers.
stay here for an hour or so to work your welcome. You know where our coffee machine is. Thank you. Thank you. Thanks.
Hospitality. Yes.
The first coffee.
That's something we are with the ONCC as well. So you don't just
I have so many questions about numbers.
It's not our they can, they're public, so that's fine. And they would invite me. What we also plan one thing that I'm told by
You need to.
That's also important. Yeah, exactly. And also because you don't know, like, if a person gives 3 accounts, you know, it will always be certain small difference. And then we had these cases. I mean, the ONCC and national authorities where a person gave account to like 2 or 3 years and your humanitarian workers. And the evidence that it was always